Welcome back to Artificially Informed, the podcast series that offers an in-depth look at the Florida Attorney General's Government in the Sunshine Manual, 2025 edition. I'm Joel Chandler, and as always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and review and edit all of the output. In today's episode 12, we're continuing our detailed dive into Part 2, Public Records, specifically focusing on B, what entities are covered, application of the Public Records Act 2. We'll be navigating pages 63 and 64 of your manual. Our discussion will cover the delegation of function test for private entities contracting with public agencies, and also look at private companies' delegated authority to keep certain records, all as outlined in your manual. To give you the deep dive you're looking for, this episode will be significantly longer than our usual 15 minutes. Let's pick up right where we left off, continuing our look at when a private entity's records become public and really unpack those details. Segment 1B, what entities are covered? Private entities, contracting, Part 2, and delegation of function test, page 63. In Episode 9, we talked about the totality of factors test, which is one way courts figure out if a private entity's records are public. Now, on page 63, your manual introduces us to the second key test for B, private entities contracting with public agencies or receiving public funds. This is the 2 delegation of function test. This test is often a bit simpler and more direct than the totality of factors approach because it zeroes in on the nature of the specific activity being performed by the private entity. The core idea is this: if a private entity is performing a function that is an integral part of a public agency's governmental operations, or if a public agency has specifically delegated one of its governmental functions to that private entity, then the records related to that delegated function are considered public records. Think of it this way: the government simply cannot hand off a core public responsibility to a private company and then say, poof, now all the records related to that responsibility are private. That just doesn't fly. If the private entity is doing something that the public agency would normally do itself, or something that's absolutely essential to the agency's legal duties or its day-to-day work, then the records connected to that specific work are generally public. It really comes down to the action or function being performed rather than just the mere existence of a contract or the amount of public money involved. Let's break this down with a couple of real-world examples to make it super clear. Imagine a city's police department. A core governmental function of a police department is patrol and emergency response. If that city then contracts with a private security company to take over all aspects of patrolling certain city neighborhoods and responding to emergency calls within those areas, that private security company would likely be performing a delegated governmental function. So their patrol logs, incident reports, and even internal communications related to those delegated patrol duties would become public records. The private company is essentially standing in the shoes of the public agency for that specific function. Another common example involves public transportation. If a county transportation authority usually operates all its bus routes, but then contracts with a private bus company to run a significant portion of those routes, that private company is likely performing a delegated governmental function. The maintenance records for those buses, the passenger manifests, accident reports, and financial records directly related to operating those routes would then typically be public records. This principle extends to various areas. For instance, if a public hospital delegates its patient billing and collections to a private firm, the records relating to those billing and collection activities would be public. Or if a county's animal control services, a traditional public safety function, are completely taken over by a private humane society under contract, the records related to animal pickups, investigations, and adoptions might become public under this test. The integral part aspect is key. It's not just any contract. It's a contract for a function that is deeply intertwined with the public agency's core mission. The courts look to ensure that agencies aren't using private contracts as a loophole to avoid transparency. This core idea that a private company performing a governmental function can be subject to public records law under this test remains a vital tool for ensuring transparency. Other cases have consistently affirmed that when a public function is truly delegated, the associated records follow the law, regardless of who is physically holding them. This test helps maintain transparency even when public services are delivered through private partnerships. It helps to ensure that essential public services, even if performed by private entities, don't become opaque to the public. The focus isn't just on who holds the record, but squarely on the public nature of the work documented in the record itself. The agency, by delegating the function, retains an inherent responsibility for the transparency of that function's operations and records. Segment 2, B. What entities are covered? Private company delegated authority to keep certain records, page 64. Now let's move to page 64 for a very specific but incredibly important scenario regarding private entities. C. Private company delegated authority to keep certain records, 2.c. This point addresses situations where a private company might not broadly fall under the Public Records Act based on the totality of factors or delegation of function test for its general operations. In other words, their overall business might remain private. However, this specific provision kicks in if a public agency explicitly gives that private company the authority to keep records that would otherwise be public records. When this happens, those particular records in the private company's custody remain public records. Here's the key implication. The public agency is essentially outsourcing the custody or storage of public records, not changing their public nature. The act of delegating the authority to store, manage, or maintain records does not by itself transform those public records into private records. The public entity simply cannot offload its records to a private entity as a way to circumvent public access laws. The public's right to know doesn't disappear just because the records are physically located off-site or in a private company system. Let's illustrate this with an example. Imagine a county government decides to move all of its old paper planning and zoning maps, which are clearly public records, to a private digitization and archiving vendor. This vendor takes possession of the physical maps, scans them into digital files, and stores them on their own secure servers. Even though the private vendor is now physically holding these digital files and the original paper maps, those records still remain public records subject to Chapter 119. The county has simply delegated the keeping and management of the records, not their public status. The public still has the right to access them, and the county still has the ultimate responsibility to ensure that access is provided. This scenario is becoming increasingly common with the rise of cloud computing and third-party data storage providers. If a city uses a private cloud service to store its official emails, city council documents, or departmental databases, all of which are public records, those records remain public even though they are technically held by a private cloud provider. The city retains the legal obligation to retrieve and provide those records upon a public records request. This means public agencies must ensure their contracts with such private companies include clauses that mandate compliance with Florida's Public Records Act, giving the agency the necessary access and control over the data to fulfill public records requests. It's not enough to just store it. They must be able to retrieve it for public inspection. This specific provision ensures that government records cannot be hidden simply by transferring their physical or electronic location to a private custodian. The records retain their public character, and the public agency still has the absolute duty to ensure those records can be inspected and copied by the public, just as if they were held in the agency's own filing cabinet or server. It's another important safeguard embedded in the law to prevent agencies from trying to avoid transparency by using private entities for record management. This concludes our detailed discussion of the delegation of function test and the rules for private companies' delegated authority to keep records. Thanks for listening. In our next episode, episode 13, we'll continue exploring what entities are covered. By looking at subcontractors and other statutory provisions governing records of private entities, taking us through page 66 of your manual. Until next time, remember, the truth dies in the dark, so let's leave the light on.